Mrs. Chairman.
Lady, my lords, just before the short adjournment, I had shown you that part of our case which deals with the Court of Appeal's decision in Gitura, which is a case that distinguishes those functions of an immigration detention centre that constitute the provision of services from those that do not. And the reason I showed you that is so that you can see how on our case paragraph 26 of Schedule 3 applies to this case. It's not straightforward because obviously many of the things that are done in an AP will not constitute the provision of services, but some will. And so the way that we say this provision applies in this case is through 26.3, which you have in Authorities Bundle 1, Tab 6, MS 1884. If one just looks at that, this paragraph applies to a person exercising a public function in relation to the provision of a service as it applies to the person providing the service. Now, your Ladyship and your Lordship will know that our position on this point has changed since the proceedings before the Court of Appeal. And the reason why we regarded and regard this as a not straightforward point is because when one is actually considering the function of deciding where to put APs, how big they should be, where they should be put, size and location, that is itself obviously not the provision of a service. But the question is whether it is a public function in relation to the provision of a service. And the reason why we say this paragraph does apply is because at least some of the things done in an AP will constitute the provision of a service on the reasoning in Gitura.
Now, why is it not the provision of a service to provide accommodation, which is what principally an AP is? I appreciate there are features of it that cannot be done by anybody else, which is the point. But the provision of accommodation is normally one of the services supplied.
Well, there may be difficulties with that, because if the accommodation provided is accommodation where someone is required to live, then it's quite difficult to see that
would be like saying the prison was a
prison cell is accommodation. Well,
that may be the answer.
Well,
I'm just trying to wrestle with these.
I think, with respect, my lady, that is the answer. That one's got to remember that APs are places where individuals are required by licence conditions to reside. And indeed are subject to curfews and all the rest of it. So if one then applies the distinction that one sees in Gitura, that may well fall on the governmental functions side of the line, but there will be things done in an AP as in an immigration detention centre, like the provision of bedding and toilet facilities and the other things that were dealt with in Gitura that do constitute the provision of services. Now, we accept that to then say, well, your decision about where to put them and how big they should be is the exercise of a public function in relation to the provision of a service is something of a stretch. And the reason why we have felt able to submit that the court can make that stretch is, as we've set out in our case, because of the legislative history. I'm not going to go through it all now, but you see it because this point is common ground between us. But you see the legislative history set out in our case at paragraphs 24 to 26, MS 70 and 71. And it deals with, that deals with the way that the equivalent provision in the Sex Discrimination Act 1975, as inserted by the Equality Act 2006, were set out. So, but the importance of this point, so far as the points that actually are in dispute, is that it will not, in any given case, be obvious whether paragraph 26 applies. It will apply in some cases and it will not apply in others. In this case, we accept, for the reasons that we've given, that it does apply. but it will not apply in every case. Now, Lady my Lords, can I move to the central issue? We accept it's the central issue in the case, which is, at least as the case has been put now, which is direct discrimination. It was put very much in the printed case on the basis of both direct and indirect, but direct is now the primary basis on which the case is put. Now, I said at the start that I would have to make good the proposition that in each of the cases that my learned friend has referred you to, there can be discerned a detriment or disadvantage which is suffered by all those sharing the protected characteristic and only those sharing that characteristic. Now, before I go into the cases, can I just try and introduce that point some more so that your Ladyship and your Lordships can see where I'm going? Obviously, it is right for my learned friend to point out that some girls in the Birmingham case were very good at exams and achieved the mark that was required to get them into school. But there was a detriment or a disadvantage which was applied to all girls and only girls, and that was they all had to get the higher mark, a higher mark than the boys, in order to get into school. Take the James and Eastleigh case, the swimming pools case. There was a detriment or disadvantage that was applied to all men. They had to wait until they got to the age of 65, whereas it would have been 60 for women, to qualify for free admission.
But
so,
all girls did not have to get a higher mark than all boys. Basically, it was an average thing. The average mark required of the girls was higher than the average mark required of the boys. Any individual girl might or might not do better than any individual boy, because after all, boys are bright too. So
right.
we're talking in that case about they suffered a disproportionate risk of failure because there were fewer places available.
well, Lady, with respect, we would say that that's not the correct analysis, because when one looks at... And
of course you say it's not the correct analysis.
Well, of course we do, and I'm going to try and show it's not the correct analysis by reference to my lady's own analyses of the Birmingham case in subsequent case law. Because actually, when one looks at it, the thing that disadvantaged the girls in the Birmingham case was that they had to get a higher mark than the boys did to get in. And why did they have to get a higher mark? Well, because there being fewer girls' places than boys' places, it was necessary for them to get, let's say, 80% rather than 70% in their exam to get into the grammar school. So,
but wouldn't there be some years when 70% would do?
Well, I want to show your Lordship how it's put in the subsequent cases.
Yep.
But what was said in the Birmingham case was that there was a systemic difference in the number of places, and that meant the mark you had to get was a higher mark than it would have been if you were a boy. Now, whether it's 70 or 80% in a particular year obviously might fluctuate, but it was always going to be a higher mark than you would have to get if you were a boy. That simply flows from the number of places available. And we say exactly the same analysis can be applied to James and Eastleigh, and exactly the same analysis can be applied in the Roma rights case. There was a disadvantage which was visited on every Roma applicant for entry clearance at Prague Airport, and that was they were subject to more intrusive questioning. Now, some of them, a very small proportion, as it turned out, would, despite that intrusive questioning, nonetheless get entry clearance. But they were all subject, because they were Roma, to a disadvantage, and the disadvantage was more intrusive questioning. And we say what is fundamentally different between those cases is that there is no disadvantage that can be discerned here which is applied to all women and only women as a result of the configuration, the current configuration of APs. And
Are you confusing potential disadvantage with actual disadvantage? Aren't you saying everyone's subject to a potential disadvantage, even though some may not suffer actual disadvantage?
well, you may put it like that, but one has to identify a criterion which in principle impacts all members of the group sharing the protected characteristic, and that is a common feature of every single one of the direct discrimination cases, we say. And unless you can do that, then the case that you're dealing with is not a case of direct discrimination. And the point was put on a number of occasions. Well, Miss Rose said, well, of course, there are no towns or cities in the United Kingdom where there is a women's AP but not a men's. In fact, there are two, Bedford and Preston, where there are women's APs, not men's APs. So if one moves, puts it this way, what's the disadvantage that affects all women and only women in this case? Well, there isn't one. If you are a woman who lives in or near Bedford, or indeed in Bedfordshire or Hertfordshire, close to Bedford, then you are not going to be subject to the disadvantage. If, on the other hand, you do what Miss Rose has suggested on a number of occasions the Secretary of State should do, which is move the women's AP in Bedford to London, then, of course, you are going to disadvantage the women who currently live in Bedford and in Bedfordshire and Hertfordshire, etc. So there is a fundamental and principled distinction between the direct discrimination cases that my learned friend relies on and this case. And I want to show your lordships and your ladyship that by reference to the analysis in the case law. And can I start with a very recent judgment of this court, judgment of my Lady Hale in a case called ONU, which is in Authorities Bundle 3, tab 37, MS 2807. Now, this is it's a good case because there's only one judgment, and the argument, the issue in the case was whether discrimination on grounds of immigration status was discrimination because of nationality or national origin. And one can see the way that the argument was put at paragraph 23 by Mr. Allen, who's appearing for the appellant in the case. Mr. Allen's entirely correct to say that immigration status is a function of nationality. British nationals automatically have the right of abode here. Non-British nationals, apart from Irish citizens, are subject to immigration control. But there is a wide variety of immigration statuses, etc. So one can see the way the argument is put. Then at 27 to 28, one can see after dealing with the particular facts of the case, there is then an express adoption, we would say, of the approach of Advocates General Jacobs and Sharpston in the Schnorbus and Bressol cases. I'm going to come to those in a minute. Pat Malnice, which was the first case in which this court adopted those two formulations, was about whether a residence requirement, which all British nationals but not all non-British nationals could meet, was directly discriminatory on grounds of nationality. Then there is set out Advocate General Jacobs' formulation in Schnorbus, and after that, Advocate General Sharpston's formulation in Bressol. Now, at paragraph 29, that's to say, the complete correspondence test, if I can put it like that. I think that was the way that my Lord Toulson put it in argument this morning, is applied to Preddy and Bull. That case, Lady Hale says, would undoubtedly have been indirect discrimination, as same-sex couples were not then able to marry and thus fulfil the criterion, whereas opposite-sex couples could do so if they chose. But the majority held that it was direct discrimination because the hotel keepers expressly discriminated between heterosexual and non-heterosexual married couples. The couple in question were in a civil partnership, which for all legal purposes is the same as marriage. And then at 30, my lady rejects the suggestion that mental process cases are different. All cases are the same, and the question is what criterion was in fact being adopted by the alleged discriminator. Now, what we say that Onu, and indeed Preddy and Hall, which I'm going to come to in a moment, show is that what you're looking for in a sex discrimination case is a criterion that is or is indissociable from sex.
But what you have is sex here. There is absolutely no doubt that you have sex here.
Yes.
You are making different provision for women than the provision that you make for men. So that's really not the problem. The problem is whether that is treating somebody less favourably. That's the real problem.
Well,
I mean, it doesn't help to make these things more complicated than they actually are.
Well, but, Lady, with respect, what is in dispute here, and was not accepted by the courts below, was that any less favourable treatment here is because of sex. So it's the link between the less favourable treatment and sex.
Well, that's why I am saying what has to be shown here is less favourable treatment. That's what discrimination in the particular statutory sense means.
Yes.
There is no doubt that sex is being treated as the criterion for a different provision of APs. There is no doubt about that. Well, the question is whether it's less favourable, and if it is less favourable, whether it's justified.
No, well, with respect, my lady, we don't accept that way of putting it, because clearly, if you are placed, we do accept that if you are placed in an AP that is far from your home and that is difficult to travel to or from, that is less favourable treatment. We've always accepted that. Now, the next question is, obviously, whether you can be placed in a particular AP does depend on sex, because they are single-sex institutions. That's accepted by everyone. Nobody here is suggesting that they should be mixed. So that is a starting point that we all have to start from. Then the question is whether the less favourable treatment, that is to say, whether the fact that you are placed in an AP that is far from home is itself treatment that you have received because of your sex. And that's the issue that we've been grappling with. And that's the question to which these tests provide the answer, with respect. And one can answer it, as we do in our case, in three ways. We've set it out at paragraph 48, and my learned friend went to that paragraph and tried to deconstruct it. But let me try and go back to that and make good the propositions that we make there. We say, first of all, it cannot be said that the category of those receiving the advantage, and here we're talking substantive advantage, we'll come on to what Lord Wilson described a moment ago as a potential advantage. Let's just concentrate on the substantive advantage. It cannot be said that the category of those receiving the advantage, placement in an AP close to home, and the category of those receiving the disadvantage, placement, the correlative disadvantage, which is placement in an AP far from home, coincides exactly with the categories of men and women. So that cannot be said, because there are obviously some women who are very close to home, and there are some men who are far from home. So that's the first point. We accept that's not the be-all and end-all, because we know that some girls got into grammar school, even though it was more difficult for them. Next question. The configuration of women's AP, men's and women's APs, let's concentrate on, will be beneficial to some women, that is, those whose homes are close to them, and detrimental to others. So that's the current configuration. So some people are going to be benefited by this configuration. Some people will be disadvantaged by it. Just depends where you live. And the same is going to be true of any possible configuration. Wherever you put the APs, however many there are, some women will be advantaged by that configuration and some will be disadvantaged by it. And we say that fact is fundamental in distinguishing this case from cases like Birmingham, James and Eastleigh, Preddy and Hall. Because in Birmingham, the fact that there were fewer places for girls than boys operated as a disadvantage, call it a potential disadvantage if you like, for all girls. Because they had a higher hurdle to jump to get into grammar school. Similarly, in James and Eastleigh, disadvantage for men as a category, because they had to wait longer to get their free admission to swimming pools. And similarly in Preddy and Hall, where the requirement that those wishing a double room had to be married, but what that actually meant when you looked at the facts was in a heterosexual marriage. That was the key. That's why my lady and my Lord Toulson, in the majority in that case, found that there had been direct discrimination. That was the key to it, that actually you had to be in a heterosexual marriage to satisfy the criterion that was actually being applied by the hoteliers in that case. That operated as a disadvantage for all gay people as a class. Why? Because heterosexual people could in principle satisfy the criterion by being married or getting married, and gay people could in principle not.
No, that isn't the reason. That isn't the reason why it was direct discrimination in that case. The reason why it was direct discrimination in that case is that they limited the provision of double-bedded rooms to heterosexual married couples.
Yes, I agree, and that operated as a disadvantage in principle for gay people as a category.
Well, it was heterosexual. That is by definition.
Yes, exactly.
Sexual orientation. I mean, that is express.
Absolutely, and that, with respect, makes my point for me, that what was going on in that case was the application of a criterion which operated as a disadvantage to the entire group sharing the protected characteristic, that is, to gay people as a group, and to every gay person. And can I show you where that point is made good in the authorities? Perhaps the best one to start with is the JFS case, which I think we haven't looked at, but just ask your ladyship and your lordships to look at that case. So Authorities Bundle Volume 2, tab 24, MS 2367. Now, I'm not going to read it out, but at paragraph 56 and following on MS 2396, we have my lady's discussion of the difference between direct and indirect discrimination. And one can see that at 56 and 57. Then at 58, there is a discussion of the Birmingham case, and one can see it being said there, it's never been suggested that it set the law on the wrong track, quite the reverse. And then this, as is well known, there were more grammar school places for boys than for girls in Birmingham, with the result that girls had to do better than boys in the entrance examination in order to secure a place. That's the key point, we would say, about the Birmingham case. And then if one turns forward in that case to see Lord Clarke's analysis at 132 and onwards, 133 is where the Birmingham case is discussed by Lord Clarke. Girls were required, the first class of case, he says, distinguishing there between two classes of case, one where a criterion is being applied and one where there is a subjectively racial motivation. But if one looks at 133 on page MS 2424, he says the first class of case was established in the Birmingham case where, as Lord Mance puts it, girls were required to achieve a higher standard than boys for grammar school entry because of a disparity in the number of grammar school places for boys and girls. That was the vice in the Birmingham case. They were required to jump over, if you like, a higher hurdle. The criterion that was being applied
Both
to
of my
them,
colleagues in that case are summarising the Birmingham case,
yes.
but we've looked at it this morning.
Yes.
And they'll forgive my saying that if one had been pedantic, one would have said girls were mostly required, or most girls were required. So this is a brief encapsulation of the factual situation that is 99% accurate.
We would respectfully say it's 100% accurate. It's 100% accurate because if you have a substantial difference in the number of places, and yet boys and girls do roughly equally well in exams, which was the position, then it will always be the case that it will be more difficult for girls to get in than boys. That was the vice. And that was why direct discrimination was established in that case. If there had not been a disparity in the ease of getting in, then the direct discrimination claim would not have succeeded.
But of course, some girls would find it just as easy as some boys. I mean, there are very clever girls, and they would find it just as easy as some of the very clever boys. The point is that the minimum standard required of the girls was higher than the minimum standard required of the boys.
Exactly. So all girls were subject to a disadvantage. What was the disadvantage? Having to achieve the higher standard. Some surmounted it. That doesn't matter. The fact is that all girls and only girls were subject to the disadvantage. And that is the proper, we say, explanation of the Birmingham case. Now, if one looks at the way that Lord Clarke put it, he then goes on to look at the Eastleigh case. He puts it in precisely the way that we say identifies the disadvantage to which all of the relevant group sharing the protected characteristic were subject. It's at the bottom of page 2425, paragraph 135. If you were a woman, you could swim at 60 without payment, whereas if you were a man, you had to wait until you were 65. That's the disadvantage that all men were subject to, and only men.
I can see that in some cases, but most cases,
yes,
congruence between the protected characteristic and the treatment may demonstrate that the less favourable treatment is because of the protected characteristic. But does it have to be so? I mean, under Section 13 of the Act, if somebody says, well, because you're a woman, you're not going to get this, is it anything to the point that they make exceptions in the case of some women? In other words, they don't discriminate against everybody.
Well, in that case, when you're talking about, for example, an employment case, let's say, where an individual woman is saying, I was treated less favourably because I'm a woman,
Yes.
but other people may not be, then the group that you're looking at is necessarily a hypothetical group rather than an actual group.
As Lord Nichols says, you don't necessarily have to start by looking at a comparator. If a complainant can simply say, it's demonstrable that I was treated in this way because I was a woman, look, here is the evidence.
Yes. Well,
And the employer says, well, I don't treat all women like that. The response might be, well, I should hope not, but there's no excuse for doing it to me.
yeah, of course, that's right, my lord. And one sees from cases like Shamoon and Nagarajan that there can be cases, particularly in the employment context, where it is, as Lord Nichols has said, not necessarily helpful to look at comparators. But where one is looking at a case where a systemic policy is being challenged, such as this case, you do necessarily have to look at comparators to see whether it can actually be made out that the reason for the less favourable treatment was sex. And that is in dispute here. I say, in an employment case, you may look at hypothetical comparators and you may say, well, let's just imagine that this person had not been a woman but had been a man. Would she have been treated differently? And if the answer to that is yes, well, then she's made out her case of direct discrimination.
Where's the case which
say?
Where's the case which starts the line of authorities about what you say is total congruence?
Yes.
Which is the case which starts that?
Well,
and have we got it as a principle that is stated somewhere? You can only have discrimination, direct discrimination under 13, where you can identify a comparator group. The complainant falls within one group, the comparator is another group, and there's total congruence.
Well, the two passages from the two advocates general are first cited by this court in a case called Pat Malnice.
Yes.
They then cited both by the majority and by the minority in Preddy and Hall. I think that's a point that my lord referred to earlier. Lord Neuberger agrees with Lady Hale that that is the correct test. They disagree on how to apply that test on the facts, and my lord, Lord Toulson, was appeared to be the deciding judge in that case, saying actually the reason why it's appropriate to apply it as a case of direct discrimination on the facts of Preddy and Hall was because the legislation made civil partners analogous to married couples. And therefore, the correct analogy was between a civil partner and a married couple, and they were being discriminated, that they were being treated differently because the hoteliers did not accept gay marriage as being a valid form of marriage.
I'm just trying to work out in my own mind how far, in what circumstances, this total congruence principle applies and has been developed, and on what logic.
Yes, well, and it's been applied finally in ONU, as I just showed you, in my lady's judgment in ONU, and applied. So the same approach was said to apply in that case, whether you are dealing with a criterion case or you're dealing with a mental process case. In other words, the attempt to distinguish the two was rejected.
You can say that it goes back to James.
Yes.
Because the council was not saying that they were discriminating against men.
Yes.
Their criterion was pensionable age. It just so happened that pensionable age discriminated between men and women. Yes. So
they were using a criterion that was indissociable.
You're using a different criterion. You're not using the criterion of gender, but it is in fact indissociable. I think James is the first case that does that. Whereas here, of course, you are using a criterion that is indissociable.
My lady, of course you are using it.
You're definitely doing that. And the real question is whether it's less favourable treatment.
Well, the question is whether there's a link between the less favourable treatment and the criterion. Because it's clear that if one asks the question, well, why was this appellant not admitted to a particular AP, which is a men's AP? Well, obviously the criterion there is sex. So obviously we accept that admission to a particular AP depends on your sex. That must be so ever since 2008 and the joint inspection report, which said that mixed sex AP should be phased out. So everyone agrees with that. Everyone agrees there should not be mixed sex APs, and therefore your admission, whether you can be admitted to a particular AP or not, is always going to depend on your sex. The real question is whether the disadvantage claimed here is because of your sex. And we say it's not, and we've given two of the reasons. I've been through two of the reasons in paragraph 48 of our case. 48C, we make the point that actually what controls, if I can put it this way, whether you will be admitted to an AP that is close to your home is not your sex, but it's the location of your home in relation to the available AP. And that is going to, the current configuration is going to benefit some women and it's going to disbenefit some men. Now, what would be the consequence?
You've said that
Yes.
quite rightly.
Yes.
The current configuration benefits some women and disbenefits some men.
Yes.
Any reconfiguration that we did
Yes.
would benefit some and disbenefit others.
Exactly
But
so.
I expect all of us are thinking, that's right, but is he able to require us to put away the whole law of discrimination, even though mostly the prejudice is suffered by women?
Well, that, if I may say so, my lord, is a perfectly fair question, but it focuses on indirect discrimination, really. Because when my lord puts the issue to me in that way, it is couched in terms that are redolent of indirect discrimination. And then the question is, as we know, can you identify a PCP? And we accept that you can identify. The appellants have identified a PCP here. So we absolutely accept that there's a PCP that falls to be justified. And that's the practice of putting people in APs. And that's a gender-neutral PCP.
So the appeal falls through the net on both.
Well,
even though
it doesn't fall
even though overall women are far more likely to be prejudiced by this.
Well,
you neatly get out of the direct, and in 10 minutes you'll be neatly getting out of indirect.
no, I'm not neatly getting out of any of them because when we come to see what the PCP, whether this can constitute indirect discrimination, the answer is they have identified a PCP. They've put one forward, and we accept it's a proper PCP. And that's the PCP of imposing residence conditions requiring residence in an AP. That's a perfectly plausible PCP. The question is, can we justify it? And we say, yes, we can. We can justify it on grounds of prevention of, or promotion of rehabilitation and protection of the public. And then the question is, well, can they identify any other PCP that is neutrally applied but is also applied to the appellant? And we say there it's very difficult to do so. If you try to identify a PCP as a PCP, the current configuration of women's APs, well, that doesn't qualify because it's not applicable to both genders. And that's one of the criteria for a PCP under Section 19 of the Act. So we do say that this structured approach has to be applied bit by bit. The first question is it direct discrimination? To which we say the answer is no, because there is not an exact correspondence between any disadvantage that one can identify and a group sharing a protected characteristic. And then the next question is there a PCP that has been put forward? One can imagine others. I mean, one could, for example, put forward a PCP of the practice, for example, of having APs that are roughly, broadly, the same size. You've seen that actually women's APs are in fact smaller on average than men's. but they're broadly speaking of a similar size. The average for women is 19, the average for men is 22. So maybe you could put forward a different PCP, and the PCP would be having APs that are broadly the same size. And then the Secretary of State would be required to justify that PCP, be required to come forward and say, well, actually, here are the reasons why we've decided that it is a good idea to put forward that PCP. That's not the one that's been relied on, and therefore it's not the one that we have sought to justify.
All that would raise the question of proportionality under Schedule 3, paragraph 26(2).
Or under Section 19. Indeed.
Okay, but just going back to your proposition,
yes,
that the cause of the unavailability of AP accommodation isn't that the person is a woman, but because where she's chosen to make her home. Let us test that. If the Secretary of State decided to place all AP accommodation for women in the remoter end of the peninsula at the southwest of Cornwall, would it be tenable to say the fact that that meant that 99% of women were located way, way away from their home, and nothing to do with their being women, but all to do with the fact that they had chosen not to make their lives in the southwest of Cornwall?
well,
Does it?
well, there are two possible answers to that. So one is that if you're dealing with a very extreme example where
Yes.
you have all the accommodation
Yes.
in one part of the country,
Yes.
you're probably not dealing with an AP which is actually anything like the APs that men go to. So you may have a problem of comparability in the first place. But the second point in relation to that is that it may very well be, if there were a policy, for example, as Lord Justice Elias said, that actually for women, we want to have the APs in John O'Groats or in Cornwall, that would be discriminatory for another reason, which is that the policy of doing that for women but not for men would be itself tainted by sex, considerations of gender. And so, as Lord Justice Elias said, if that were the policy, then plainly that would be unlawful for a separate reason. But what we have at the moment is we have a configuration of APs which are roughly the same size, slightly smaller in the case of women's APs than men's APs. We have, as you'll have seen from the section on justification, I'll come to that in due course, we have a position where it costs the same, pretty much, to run an AP, however small it is. And that's because you have to have a minimum complement of staff under the regulations. That's a legal requirement. And so then the question is, well, what's actually being said here? What are the alternatives that are being put forward? And we can see that the alternatives that are being put forward are essentially spend a lot more money on having much smaller APs, or move some that are presently serving women in particular parts of the country to other parts of the country, thereby disadvantaging
moving on
some
from
of
the
those.
question whether there's less favourable treatment,
Well,
causation, to the question of proportionality and justification.
well,
You say you don't get to that stage.
I do say that, yes.
Because either there's not been less favourable treatment, or it's not on account of being a woman.
Yes. Well, what we say is that you have to take a structured analysis. You ask yourself first the question whether the less favourable treatment is because of sex, and I absolutely accept that the way my lady and my lord have put it, that's a simple formulation. But one does have to establish that the less favourable treatment, namely being placed in an AP far from home where travel links are difficult, is because of sex. And what the direct discrimination case law tells you is how to answer that question. And the way that you answer that question is by seeing if one can identify a disadvantage or detriment which is suffered only by the the group sharing the protected characteristic and by all members of the group sharing the protected characteristic.
And you have to compare like with like.
Yes, I agree with
So
that.
you have to compare a man living in London with a woman living in London. And you have to ask whether the fact that the woman has to go to Reading or Bedford, whereas the man can go to one of a number of APs in the London area, is less favourable treatment because of their sex. That's what you have to do.
Well, in our respectful submission, you have to look at it on a broader basis than that. But even if you look at it in that fine-grained way...
Most discrimination claims are brought by individuals claiming that they, as individuals, have been discriminated against. This happens to be a judicial review which is looking more systemically at it. But
Absolutely.
Nevertheless, we have a particular individual appellant in this case,
Yes.
whose complaint is that she is being treated less favourably than a man where the material circumstances are the same, because he can go to an AP near to home, which is going to greatly increase his chances of successful rehabilitation, whereas she can't.
Yes. Well, where one gets placed obviously depends on, as we've said, one, where your home is, and two, where the nearest available AP is. Now, of course, it's right that where the nearest available AP is itself going to be, to some extent, dependent on gender. That must follow simply from the fact that you have separate APs for the two genders. The actual question, the actual disadvantage that you've got to focus on is the difficulty or ease of maintaining contact with family and friends in your home area. And that is not, with respect, we say, something that is a disadvantage that is suffered because of sex. It's something that some people will suffer and others will not. It's not even something that every woman in London will suffer compared to every man. One just has to look at the fact that some parts of London are very easily can be travelled to very easily from Reading or indeed Bedford, and indeed that two parts of London may be very difficult to travel between if they are at different parts in different parts of the city. So it's actually not as simple as saying, even if one looks at it in the fine-grained way that my lady has suggested to me, that every woman in London will be better off if she goes to an AP in London than an equivalent man would be if he were sent to, for example, an AP on the other side of London. It simply isn't that. It isn't that simple. When one actually asks the, my lord.
No, I'm sorry. I've got a question when you finished your point.
Well, when one actually asks the question, can one say that the disadvantage, that is to say, the ease or difficulty of contact, face-to-face contact, of course there can be contact without face-to-face contact, but I accept face-to-face contact with family and friends. When one asks the question whether that disadvantage is the result of sex, the answer to that question we would respectfully submit is no, it's not. It's a function of something else, namely a whole set of imponderable factors as to where one lives and where the nearest AP that is available is. I'm sorry.
Well, I think you've actually answered the question I was about to put, but for the avoidance of doubt, may I just get it clear in my own mind? I'm sorry to keep peppering you with questions.
Yes.
Don't agree if I've got this wrong, but am I right to understand that you say, in relation to the appellant, yes, you accept that she is less favourably treated than a man whose home and family are in London, but that is not a function of her sex, it's a function of where she has chosen to make her home? Yeah.
That's right. Now, can I show you just one additional passage that we say also adopts the same approach, which is in my Lady Hale's speech in the Roma rights case, which was also referred to by my learned friend. And I said that the Roma rights case was another example of a case where a detriment, a concrete detriment, was applied to all Roma and only Roma. And that was that they were routinely treated with more suspicion than others. And one sees that at paragraph 97. It's in Authorities Bundle 2, tab 20, MS 2322. All the evidence before us, other than that of the intentions of those in charge of the operation, which intentions were not conveyed to the officers on the ground, supports the inference that Roma were, simply because they were Roma, routinely treated with more suspicion and subject to more intensive and intrusive questioning than non-Roma. So there's the concrete disadvantage that was applied to all Roma and only Roma. Now, some of them, like the super intelligent girls in the Birmingham case, were able to overcome that disadvantage and gain entry clearance despite it. But nonetheless, there was an identifiable, discernible disadvantage that was applied to them and to all those with whom they shared the relevant protected characteristic. So that's our positive case on direct discrimination. Now, what would be the consequences if, contrary to our submissions, the current configuration of APs does give rise to direct sex discrimination? Well, we say there would be three. First, and the appellant accepts this, it would mean that discrimination claims could in principle be brought by men as well as women. For example, a man from Bedford or Preston could complain that if he were a woman, he would have been placed in an AP in his home town. Now, Miss Rose's answer to that is, well, yes, but the discrimination would be easy to justify. But would it? If she's right on the standard of evidence required to make out a justification, a matter to which I'm going to come in a moment, the Secretary of State would have to provide detailed and cogent reasons to explain why there are, for example, 14 men's APs in London and none in Bedford. And if for whatever reason those detailed and cogent reasons could not be provided, every man from Bedford would have a claim in principle sounding in damages for discrimination, contrary to section 29(6) of the 2010 Act. Second consequence, imagine for present purposes that the Secretary of State decided, in order to forestall such claims, that there should be the same number of women's APs as men's APs, namely 94. But they were to be located in different places from the men's APs. It would still be possible for a man or a woman to show that the AP in which he or she had been placed is further away from his home area or more difficult to travel to than the one he would have gone to if his or her gender were different. Again, that fact would give rise to a claim, in principle sounding in damages, a discrimination claim, unless the Secretary of State could justify the allocation. Now, these first two examples, of course, assume the applicability of paragraph 26 of Schedule 3. But as I mentioned before, the applicability of paragraph 26 of Schedule 3 is not a straightforward matter, and there may be other cases where that provision does not apply. Those could include cases where the public function is not in relation to the provision of a service, or they could include cases which are outside the provisions of Part 3 of the 2010 Act altogether. It's an interesting question, not one that this court needs to resolve, but it is at least an interesting question as to whether the type of discrimination in the Birmingham case itself would fall within Part 3 or not, or would it rather fall within another part of the Act dealing, for example, with education? So we do say that if my learned friend is right, then there are significant consequences for the kind of case in which a justification defence is going to be required. Can I move on now to indirect discrimination, the indirect discrimination claim? Because obviously some of the points I'm going to make here are points that I've already dealt with in response to questions from the court. But we say, and we set this out in our case at paragraph 49, MS 80, that there's a 5-stage analysis when you're asking about indirect discrimination. There are 4 things that the appellant, that a claimant has to establish, which are: first, that the Secretary of State applied to her a provision, criterion or practice. Second, that the PCP applies equally to persons who do not share the same protected characteristic. That would be male prisoners. Third, that the PCP puts persons with whom the appellant shares the characteristic, that's female prisoners, at a particular disadvantage compared with those who do not share it, male prisoners. And fourth, that the PCP puts the appellant at that disadvantage. And then, if the appellant can show all of these things, the Secretary of State has to show that the PCP is a proportionate means of achieving legitimate aim. And that's the analysis under section 19, and it's a similar analysis that would apply under paragraph 26 of Schedule 3. Now, we set out at paragraph 50 of our case over the page at MS 81 some extracts from the judgment of Mr. Justice Langstaff, the President of the EAT, in a case called Taiwo, which was one of the 2 cases that was linked in the judgment, which is reported under the name of ONU, which we've already seen, came to this court. Those passages deal with the importance of identifying the PCP, both so as to be able to consider whether it gives rise to a particular disadvantage, and so as to understand what it is that has to be justified. And at 52 to 53 in our case, we make the very simple point that when carrying out the structured analysis required by section 19, if the claimant can establish the first 4 matters and the defendant cannot establish the 5th, the result is that the application of the PCP is unlawful. Now, that has 2 consequences. It has 2 consequences. It has a backward-looking consequence, which is that the statutory tort of discrimination is established and remedies flow from that. But it also has the forward-looking consequence that the defendant, the Secretary of State in this case, cannot continue to apply the PCP, which has been found to be unjustified. It has to be modified either by introducing different requirements for men and women or by dropping the requirement altogether. That's the ordinary consequence of a finding of indirect discrimination. And indeed, there are compulsory powers which courts have to make orders to that effect. In other words, we say the PCP you choose has to be one whose general application you could plausibly object to. So, for example, the example given by my learned friend in her case, if you're going to choose as your PCP the requirement for entry into the police that you have to be a certain height, then you go through the structured analysis. Can you establish the 4 things that you're required to establish? If so, can the respondent establish that the requirement is justified? If not, then the requirement's got to be changed, either by removing it altogether or by introducing different requirements for the sexes. Now, what is the requirement that the appellant has identified in this case? Well, the requirement that she's identified is set out at paragraph 49 of her case, and that's the requirement for a person with an AP residence condition to reside in an AP. Now, we understand that to be a reference to the practice of imposing licence conditions requiring residence in an AP. And we agree and we accept that that is capable of being a PCP. We accept that it gives rise to a particular disadvantage for women because they are more likely to be placed in an AP far from their home. And then the question is, can we justify it? But as the courts below indicated, the problem with this PCP is not that it's in principle incapable of being a PCP, it's that it's obviously justifiable. It's justifiable because it serves two legitimate aims: protection of the public and promotion of rehabilitation. And no one is saying that it is in general pointless or counterproductive to impose conditions requiring residence in an AP on prisoners. And that is how the Court of Appeal approached this case at paragraphs 55 to 56 of its judgment. And I'll just ask you to look at those paragraphs at MS 113. Um, 55, Lord Justice Elias sets out the PCP identified by Miss Rose, and he says this, he says, if this is indeed the appropriate way to identify the provision, criterion or practice, then in my view the Secretary of State can plainly show that this is a proportionate means of achieving legitimate aim. The justification for requiring residence in an AP is the better protection of the public and the aim of achieving the prisoner's rehabilitation by gradual integration into the community. That is as true for the particular APs located in their current positions as it would be if they were located elsewhere. And then you can see the remaining comments of that in that paragraph. Now, it was put to me, well, surely the result cannot be that you get off scot-free. There's no direct discrimination and there's no indirect discrimination. And my answer to that, and I repeat it here, is that it's up to the appellant to choose the PCP that she wants to attack. Now, she chose one in this case, and that was the PCP of imposing licence conditions. But as I've said, there were other PCPs that she could have chosen to fix upon, such as the practice in relation to the size, the general policy in relation to the size of APs. Now, if she'd chosen that, then we would have had the task of justifying that. And if we could have justified that, then it would have followed that there would have to be only 6 or so women's APs in the country, because, as you've seen, women's APs are already slightly smaller than men's. And if you are going to be arguing for a configuration which has many women's APs throughout the country, then you are necessarily going to be arguing for a configuration which involves much smaller APs. And in some cases, you're going to be arguing for a configuration which involves APs with a staff to prisoner ratio with more staff than prisoners. And that is actually what you would be arguing for if, for example, you doubled the number of APs. I'll come back to that point when we look at justification in just a moment. The only other PCP that the appellant has sought to identify is set out at paragraph 50 of her case. And there she fixes on another putative PCP, namely the limited provision of APs for women. That, as we've said in our case, is not a requirement that is applied equally to male prisoners and therefore is not capable of being a PCP. You have to identify something, some feature, some provision, criterion or practice which is neutrally applied both to people sharing the protected characteristic and to others. So that simply doesn't come within section 19(2)A and is not capable of being a PCP. Can I then turn to the question of justification? because this arises if the court forms the view that the current configuration of women's APs gives rise either to direct discrimination, in which case the question of justification would arise under paragraph 26 of Schedule 3, or indirect discrimination, in which case it arises both under paragraph 26 of Schedule 3 and also under section 19 of the Act, in the same way as any indirect discrimination can be justified. Now, most of the case law on justification comes from the employment context, and that case law is summarised by Mr. Justice Elias in the EAT in a case called McCulloch. I'll just ask you to look at that. That's in Authorities Bundle 2, tab 23, MS 2356. And it's at paragraph 10, going over the page to 2357. I'm not going to read it out, but there are a number of legal principles. The burden of proof is on the respondent to establish justification. The classic test is set out in Bilker-Kaufhaus. This involves the application of the proportionality principle. It has subsequently been emphasised that the reference to necessary means reasonably necessary. And then one sees reference to the objective balance, and then it's for the employment tribunal to weigh the reasonable needs of the undertaking. Now, we point out, and we've pointed out in our case, but I'll give you the reference, that this difference between necessary and reasonably necessary has been emphasised in the case law, and in particular, the judgment of Lord Justice Maurice Kay in a case called Cadman, which is Authorities Bundle 2, tab 18, and it's at paragraph 31, MS 2244. Now, what is being challenged here is, of course, not a decision by an individual employer. It is a policy decision by government about how to deploy scarce public resources. And it is no less a deliberate policy decision by government because, as my learned friend has emphasised, there's been a failure to comply with Section 149 of the Equality Act. It is still a deliberate policy decision.
You say policy,
yes.
You say deliberate.
Yes.
Isn't the evidence rather that this is how, without any thought being given to it, the matters have developed to date?
Yes. Well,
is that policy?
Well,
or is that happenstance?
Well, what has happened, and this is an important issue on the question of justification, is, as you say, there has been a historical development. Then in the course of this case, evidence has been submitted, and it's not true with respect to my learned friend to say there is no evidence on justification in this case. There is evidence, and we will show you that that evidence can properly make out a justification for either direct or indirect discrimination in this case. But there's no doubt that the current configuration of women's APs is the result of a series of acts or omissions by the government, which have borne in mind, no doubt, considerations of cost and efficiency and so forth. Now, what you see at the moment is that there are a number of women's APs, namely 6. They are roughly the same size as the men's APs, and there is, in evidence on the question of justification, quite detailed evidence on the question of how much it would cost to do things differently and what the provision would look like if things were done differently. And we say when one looks at that, it is perfectly appropriate to apply the kind of margin of appreciation which is generally applied to policy decisions by government about how to deploy scarce public resources. Now, there are 2 cases that we particularly rely on in that regard. One is the Seymour-Smith case, which will be, I'm sure, familiar at least to some members of the court. And that's the case which you have in Authorities Bundle 1, tab 12, and it's at MS 2042. And this is the Seymour Smith case after it came back from the Court of Justice of the EU and came to the House of Lords. Lord Nichols is here summarising what he understands to be the position as set out by the Court of Justice of the EU. The answer given by the Court of Justice to the fifth question referred to the Court by this House, which was a question about justification, is now shown...
Which page are you on?
I'm sorry, it's 2042,
Okay.
and it's at letter F.
Letter F.
Thanks.
The burden placed on the government in this type of case is not as heavy as previously thought. Governments must be able to govern. They adopt general policies and implement measures to carry out their policies. Governments must be able to take into account a wide range of social, economic and political factors. The Court of Justice has recognised these practical considerations. If their aim is legitimate, governments have a discretion when choosing the method to achieve their aim. National courts acting with hindsight are not to impose an impractical burden on governments which are proceeding in good faith. Generalised assumptions lacking any factual foundation are not good enough, but governments are to be afforded a broad measure of discretion. The onus is on the member state to show, one, that the allegedly discriminatory rule reflects a legitimate aim of its social policy, and two, that this aim is unrelated to any discrimination based on sex, and three, that the member state could reasonably consider that the means chosen were suitable for attaining that aim. Now, we say that that is consistent with another line of authority which you see in the context of age discrimination, and we've cited, there's a whole line of it, but the most recent example is a case called Unland, which is in Authorities Bundle 4, tab 46, MS 3054. So if one looks at MS 3054, paragraph 57, this is about what test you apply when asking whether a measure which has been found to discriminate on grounds of age is proportionate to a social policy objective within the meaning of the directive. And the answer is, it should be noted that under EU law as it currently stands, the member states, and where appropriate, the social partners at national level, enjoy broad discretion in their choice, not only to pursue a particular aim in the field of social and economic employment policy, but also in the definition of measures capable of achieving it. And we say that that is actually consistent with the approach taken to discrimination under Article 14 of the ECHR, and the approach there is summarised by Mr. Justice Sales, as he then was, in a case called Crown on the Application of S, and the Secretary of State for Justice at paragraphs 91 to 93, which you have at Authorities Bundle 3, tab 29, MS 2607. Now, I'm going to say very little about the next topic, which is the question of cost, because there is, as you know, an unresolved issue, at least at this level, about the extent to which cost can be taken into account in deciding whether a measure is justified. But there is a decision of the Court of Appeal called Woodcock, which you have in Authorities Bundle 3, tab 27, and it's at paragraphs 65 to 66 in the judgment of Lord Justice Reimer, MS 2540, and he says, he acknowledges there that almost every decision taken by an employer is going to have regard to costs. Well, we say the same must be true a fortiori of a decision taken by the government about the deployment of scarce public resources. And just to take a very extreme example, we could provide complete parity in AP location and number between men and women. We would do that by providing 94 women's APs. Each one of them would have one woman in on average. That's what parity would mean in this case. Now, obviously, that would have resource implications, and it cannot be right in our respectful submission that you leave out of account those resource implications. It's right to say that Lord Hope and Lady Hale, giving the judgment of this court in O'Brien, expressly left open the question whether Woodcock was correctly decided. But we say it really doesn't matter in this case for two reasons. The first is that the only PCP that's actually relied upon here is the practice of imposing licence conditions requiring residence in an AP. And that PCP serves an obviously legitimate aim, or two obviously legitimate aims, promoting rehabilitation and protecting the public. Now, if some other PCP were going to be relied upon with a view to suggesting that the Secretary of State should have established a larger number of smaller APs, a separate legitimate aim could be prayed in aid, as Lord Justice Elias said at paragraph 64 of his judgment, MS 115, that of ensuring that men and women are placed in roughly similarly appointed establishments. Obviously, if you have 94 women's APs, they're not going to be similarly appointed to the men's APs, because they're going to have something like 12 staff in them for each woman, unlike the men's APs, which will have something like half a member of staff for each man. Now, finally, I need to address just on the question of the test for justification, the question of objective justification. The question of the relevance to objective justification, rather, of Mr. Justice Cranston's finding that the Secretary of State breached the public sector equality duty. Well, we accept, of course, that this means that the justification that we are putting forward is an ex post facto justification. Obviously, that's right. And that means, we accept, it needs to be carefully scrutinised. But we also emphasise what was said in the case of Selden against Clarkson, Wright and Jakes, which you have in Authorities Bundle 3, tab 28, MS 2564. At paragraph 59. And we do rely on that paragraph as a whole. The fact that a particular aim is capable of being a legitimate aim under the directive is only the beginning of the story. It is still necessary to inquire whether it is in fact the aim being pursued. And then the ET considered in that case, which is an age discrimination case, that the aim, the ET, the EAT and the Court of Appeal considered on the basis of case law concerning indirect discrimination that the aim need not have been articulated or even realised at the time when the measure was first adopted. It can be an ex post facto rationalisation. The EAT also said this at paragraph 50, a tribunal is entitled to look with particular care at aims which in fact were not or may not have been in the rule maker's mind at all, but to treat as discriminatory what might be a clearly justified rule on this basis would be unjust, would be perceived to be unjust, and would bring discrimination law into disrepute. And we do say that that emphasises the very clear and obvious distinction between the procedural obligation imposed on public authorities by Section 149 and the substantive obligations imposed under the Act. Now, one can make that point good by returning to this issue on which I was quizzed before lunch. Just imagine for a moment that we succeed on the discrimination arguments. We succeed on saying that it's not direct discrimination, it's not indirect discrimination, or if it is, it's justified. We will still have to remedy the breach found by Mr. Justice Cranston under Section 149. We will still have to comply with our duty. Obviously, the court's finding that the arrangements are not discriminatory, or if discriminatory, are justified, will be an important factor that goes into any quality impact assessment which satisfies Section 149. But as I said before, that's not the only thing that Section 149 is directed at. Section 149 is also directed at encouraging equality of opportunity, which goes beyond merely eliminating unlawful discrimination. Perhaps I just make that point good by inviting your lordships and your ladyship to look at Section 149 itself and see that it is broader than simply eliminating unlawful discrimination. So if one looks at it, it's at page 1182, MS 1182, Authorities Bundle 1, tab 6. Sorry, 1882. And one can see that a public authority must, in the exercise of its functions, have due regard to the need to A, eliminate discrimination and any other, etc., harassment, victimisation, and any other conduct that is prohibited by or under this Act. B, advance equality of opportunity between persons who share a relevant protected characteristic and persons who do not share it. And C, foster good relations between persons who share a relevant protected characteristic and persons who do not share it. And the case law under Section 149 emphasises that these three things are different. So there is a place, if I may put it like this, for an EIA analysis that will have to be done, certainly will have to be done, whatever this court finds, even if I am right in saying that the arrangements do not give rise to unlawful discrimination. And so it simply does not follow from the fact that that Mr. Justice Cranston found there to be a breach of Section 149, that there must necessarily be an absence of justification on the facts. Now, we explain our case as to why these requirements are justified in paragraph 73 of our case. And I just wanted to look at some of the points that are made there. There's actually, go through them one by one, if I may. So the first point we make in paragraph 73, MS page 88, is that overall the number of places in APs as a proportion of those who need them is higher for women than for men. And that's an important starting point. This means, as Mr. Justice Cranston found, that there does not seem to be any difficulty with finding a place for a woman in approved premises when that is needed. Contrast the position for men, where there sometimes is a difficulty. Second, we point to the fact that the mean capacity of women's APs is already lower than that of men's. I've said 24 there. As I've said before, that's a mistake. It should be 22. So it is already lower. The third point we make there is that one that I've already adverted to, which is that the only way of achieving complete parity would be to have the same number of APs for women as for men, and that would mean that the mean capacity of them would be 1.2, as opposed to 19 now, assuming the current total capacity were maintained. Even the appellant accepts that would be absurd. Then we've said, well, look, just consider, and this is, my learned friend says, well, this is all just conjecture or legal argument. Of course, it's legal argument based on the evidence that you see put before the court in the form of Mr. Langley's statement and his exhibits. So this is not a case where the Secretary of State has no evidence. The evidence is contained in Mr. Langley's statement, and it is, in our respectful submission, evidence which is capable of making out a justification. And it does show that if the 112 places currently available in women's APs were to be split over, let's say, 12 rather than 6 APs, women would still be much more likely than men to be sent to an AP far from home. The mean capacity would drop to 9, so we'd be looking at that stage at a higher number of staff than residents. The annual running cost of women's APs would in broad terms double. That flows from the fact that it costs the same to run a small AP as it does to run roughly the same to run a small AP as it does to run a large AP.
So there's evidence that it requires the same number of staff to look after whatever the number of residents?
Well, there is a requirement under the regulations that there must be 2 members of staff on duty at all times. And from
24-hour cover,
to have 24, and then there's obviously, there have to be shifts and there have to be arrangements for people to have holidays and all the rest of it. And the consequence of that is that the cost of running an AP, this is all set out in Mr. Langley's statement, and it's accepted as findings of fact by Mr. Justice Cranston in his judgment. The consequence is that the cost of running an AP, however small, is between £500,000 and £750,000 a year. So, and that is, we say, an absolutely crucial fact that goes to justification. And then I've said to that would have to be added the cost of building 6 new APs or converting 6 buildings for use as APs. And in fact, the figures there are wrong due to my own mental arithmetic. The figures should in fact be between 9 and 13.2 million. You get those figures from Mr. Langley's statement, where all set out in Mr. Justice Cranston's judgment. The cost of building or a new AP or redesignating another building for use as an AP is between 1.5 and 2.2 million. So that those figures of 9 and 13.2 is just 6 times that. Now, we also point out in E that the provision for women, if one did do that, would be materially different than the provision for men. Women's APs would have higher staff to prisoner ratios. We say their staff would have less experience of managing residents, and I'm hauled up on that by my learned friend who says, oh, that's just an assertion. It just follows from the fact that there would be fewer residents there. And the per capita cost of women's AP places would be substantially greater than the per capita cost of men's AP places. And then finally, we do say that you do have to factor in, as both Mr. Justice Cranston and Lord Justice Elias in the Court of Appeal did, the fact that we are talking here about a placement which lasts on average for 80 days. Now, my Lord put to me, Lord Toulson put to me at the outset of my submissions, well, you're not considering the knock-on consequences. Well, again, those knock-on consequences are not the subject of evidence in these proceedings.
Well, unless we treat the evidence attached to the intervener's submission.
Well, the difficulty with that, my Lord, is that we received it for the first time yesterday afternoon.
Right.
So I do urge the court to treat that evidence with some caution. The court allowed the intervention di bene esse, didn't set a time limit by which the evidence had to be provided, and the evidence was then provided yesterday afternoon.
Sure.
We have not responded to it, and we are not to be taken as accepting in that evidence.
Did any of the review reports, the Corston report and so on, the select committee's report, deal with the longer term consequences of being put in an AP a long way away from home?
I don't know offhand the answer to that question, but can I just commend what we say about the Corston and other reports in our case, because we do deal with this at paragraph 6 of our case, MS 664. And what we say there is we say that Mr. Justice Cranston was right to say, as he did at paragraph 62, that he was not sure that these reports can bear the weight that Ms. Rose sought to place on them. He was right to say that because actually the only one of them that distinctly raised the issue of discrimination is the joint inspection report. And actually, when one looks at the Corston report, the emphasis in the Corston report is actually on bail. So the emphasis we've set out in that paragraph and underlined the paragraphs which deal with bail. She says, especially for bail. Right at the outset of my learned friend's submissions, she said, of course, that APs deal with post-prison placements and also with bail. And we've pointed out here that actually the Secretary of State did take measures to deal with the position in relation to bail, which are set out in Mr. Langley's statement at paragraph 4.5, appendix page 122. So one has to be very careful with these reports. They are dealing with a very large subject matter. They're dealing with prisons. They're dealing with probation.
Pre-trial, is it?
Yes. They're dealing with prisons, they're dealing with probation, they're dealing with bail, they're dealing with a whole range of factors, some of which have been separately addressed. And it is not right to say these are reports whose primary function it was to look at this particular issue. When one looks at the Select Committee report, as we've set out in 6B, actually that report doesn't really bear on this problem at all. So that's what we say about justification. We do say that the fact that one is dealing with an average stay of 80 days is highly relevant, because if what's being suggested is, how can I put it, well, we'll see what's being suggested in just a minute when one looks at, we've addressed this at paragraph 75 of our case. When you put forward a PCP, or you put forward something that has to be justified, you are inevitably attacking a particular policy or way of configuring the provision. I see the time. I hope I'm...
You saw me looking at it, didn't you?
I did see your ladyship looking at it. I was going to point out that my learned friend took a little bit of
I know, I've
extra
factored
time.
that in.
Right, I see. Well, let me just deal very quickly then with what we say at paragraph 75 of our case, MS page 90. Because you really have to look at what the alternative provision that the appellant is putting forward here is. What does she actually say we should be doing here? Well, of course, her first submission is, well, that's not for me to say. All I have to say is you haven't done a good enough job, and that's the end of the story. Well, we say that is too simplistic an analysis. You have to look at least what the alternative provision that is suggested is. And the first one is, well, you could replace one of the current women's APs with a larger number of more widely spread facilities. Well, we've dealt with that under the main heading of justification in our paragraph 73. Well, you could close one, she says, close one of the current existing women's APs and move it, say, to London. Well, that's great if you're in London, but less good if you're in Bedford or in Bedfordshire or near Bedford. And we point to the fact that, of course, Kelly House in London was closed for a particular reason, namely that it was underused. You could redesignate a men's AP for women and a women's AP elsewhere for men. Well, that would disadvantage the women in the area outside of the AP, outside of London, that was going to be redesignated. Or you could consider other forms of accommodation for relatively high-risk women, which is one of the suggestions made in the Howard League submission. But as we point out, that is something that is already done. Many women are sent to accommodation which is not an AP, different kinds of accommodation. The question we're looking at is focusing on those women who are required to reside in an AP. Finally, on relief, we obviously have received the declaration that has just been drafted by the appellant over lunch, the handwritten declaration which you have, and we say that that declaration suffers from exactly the same defects that we identify in paragraph 77 in relation to the declaration sought originally, and we've set them out in paragraph 77. And in light of the time, I won't say anything further about them.
Well, if we get that far, we shall be paying careful attention to everything that's said about relief.
As your ladyship knows, we say we don't get that far. My lady, my lords, for those reasons, we invite the court to dismiss the appeal.
Thank you, Mr. Chamberlain. Mr. Sanders?
My lady, my lords, first of all, the question about the failure of the Secretary of State to take any action since 2013. Well, what was said by Mr. Chamberlain was, well, that was because of the pending appeal. Now, there are two answers to that. The first point is that, in fact, the Secretary of State took no action since 2008, because it was in 2008 that the joint inspection report was produced, specifically identifying the problem of discrimination and making recommendations that there should be a network of smaller, more widely distributed women's APs. And it was in reaction to that report that the Secretary of State took no action at all, save for the probation circular that we looked at, which simply acknowledged that it was going to have no significant effect on equality of treatment. And if I can just give the court the reference in Mr. Justice Cranston's judgment, you will see that at paragraphs 63 and 64 of his judgment, that's at MS 141, he specifically makes that point. And he also makes the point in those paragraphs that this was a purely historical accident and that there was never any policy decision taken by the Secretary of State. So this is the point that the defendants have failed to engage with at all. Now, since 2013, with respect, it's simply not right to suggest that nothing could have been done while the appeals were pending. If we look back at what Mr. Justice Cranston said at paragraph 65, that's at MS page 142, what he said is that the Secretary of State must address possible impacts, assessing whether there's a disadvantage, how significant it is, and what steps might be taken to mitigating it. Now, that could have been done without the Secretary of State admitting that there was any unlawful discrimination in this case. But the Secretary of State chose to do nothing, and at no stage has put forward any explanation of the reasons why. Now, what Mr. Chamberlain did was to say, oh, well, we couldn't be expected to do an equality impact assessment while the appeal was pending. But compliance with the public sector equality duty is not the same thing as conducting an equality impact assessment. What the public sector equality duty requires is that due regard is had to the various considerations set out at 149. The defendant here had the benefit of a judgment from Mr. Justice Cranston telling her exactly what she needed to do in order to comply with that duty, and she chose to do nothing. And she chose to make no explanation at any time to any court as to the reasons why not. And it's not good enough for my learned friend to point to a paragraph from Mr. Justice Elias speculating as to why it might have been done in the face of this finding and the decision not to explain it on the part of the Secretary of State. Now, then turning to the question of direct discrimination, the submission that was made by Mr. Chamberlain was that we have to show that there has been a detriment suffered by all those with a protected characteristic and only by those with a protected characteristic. With respect, that is not the law. The law is, in accordance with Section 13 of the Equality Act, that what must be shown is that the individual in question has suffered less favourable treatment because of her sex. It matters not whether other people have not suffered less favourable treatment because of their sex. What the case law, to which my learned friend referred, demonstrates is that in a situation where the alleged discriminator is denying that the reason for the treatment is a protected characteristic and saying it's not sex, it's pensionable age, or it's not sexual orientation, it's marital status, or It's not nationality, it's residence. In that situation, one way of testing the proposition, whether in truth the reason is a protected characteristic, is to ask whether the criterion that's been identified is in fact coterminous with a protected characteristic. Because if it is, the discriminator cannot be heard to say that the reason is not the protected characteristic in question. That's a complicated, difficult case, and as my lady said earlier, the origin of it is in James and Eastley. But it has nothing to do with the case where it's acknowledged and accepted that the reason for the treatment is sex. And to look at the cases, my learned friend, with respect, has misinterpreted the Birmingham case. If we just go back to it very briefly, it's Authorities Bundle 1, tab 9. It's at page 1964. It was not said by Lord Gough that every girl was disadvantaged, or even that every girl at the borderline was disadvantaged. What was said at B on this page is that there was a table placed in evidence showing the number of places offered by the 8 schools to boys and girls respectively. The table shows that girls with a test mark near the borderline have a substantially smaller chance of obtaining education at one of the selective schools than the boys. Now, one can understand why that is, because year on year, there will be different numbers of boys and girls whose parents want them to have a selective education and who therefore take the entrance exam. They won't always be the same. In different years, there will be different spreads of ability. So, for example, you might have one year where the boys are of exceptionally high ability, and therefore the pass mark is higher for boys than it is for girls, even though there are more places for boys. That could happen. There is no necessary correlation or necessary complete coincidence between sex and the disadvantage in the Birmingham case. And Lord Gough never said that there was. And as my Lord Wilson rightly pointed out, the later cases are simply summarising the effect of this judgment. They're not seeking to change, and how could they change the basis of the judgment? The point that's being made is that given the greater number of places for boys, it is inevitable that there will be girls who suffer a disadvantage because they're girls. And that is the crucial statement from Lord Justice Dillon that's approved at page 1969. It's the maintenance of the inequality by the local authority which leads to the inevitability of sex discrimination for some of the pupils. Doesn't have to be for all of the pupils. And the same is true of the Roma rights case. There was no finding in the Roma rights case that every single person of Roma origin who arrived at Prague airport received more intrusive questioning than every single non-Roma person. How could there have been? We simply would never have been able to have that evidence. What was concluded was that the evidence showed that typically that was the case. Now, there may well have been some immigration officers at Prague who made great pains not to discriminate and treat everybody equally. The problem was that when you looked at the operation overall, systemically and typically, Roma were being less favourably treated. It was never any part of our case, and it's no part of the decision of the House of Lords in that case, that every single Roma person at Prague airport was less favourably treated than every single non-Roma.
Well, the observers weren't there all the time, were they?
No, the observers weren't there all the time. They didn't know whether everybody they were looking at was Roma, and they didn't even say that every single Roma was less favourably treated. What they noted was that a far larger proportion of Roma were not permitted to fly than non-Roma, and in general, it appeared that the Roma were being questioned for longer and in a more intrusive way. But they never suggested that it applied universally to everybody. How could they possibly have made that conclusion? And those are cases where the issue is not whether a different criterion is in fact operating as a cover for a protected characteristic, but simply the question, is there in this case less favourable treatment on these grounds, either sex or race? Of course, the other cases on which my learned friend relies, James, Bull, Pat Milnice, and the Owu case, are all cases of other criteria that are not on their face a protected characteristic. And the question in those cases is, can it be said that that criterion is in fact coextensive with a protective characteristic and therefore can be equated with it? So with great respect to my learned friend, his legal analysis is simply wrong. And if it were adopted by this court, it would be the most radical and appalling development in discrimination law of the last 30 years. Apart from that, it would be fine. Now,
Never one to understate your case, Miss Rose.
No, my Lord, well, it would be a shame to do that.
Yeah.
The point my learned friend makes about Bedford and Preston, very briefly, as you will see from the map, the men's APs are very, very close by. Now, then, if you bear with me just one moment. Yes. The proposition was put to Mr. Chamberlain by my Lord Toulson, and he accepted it, that his case was that Ms. Coll was less favourably treated than a man who was chosen to live in London, and that this was not a function of her sex, but a function of where she had chosen to make her home. That was the proposition. Now, in my submission, that proposition, which my learned friend accepts as his case, demonstrates the flaw in his argument. Because the reality is that the question of where the person has chosen to make their home is part of the material circumstances of that individual. It's the comparison for the purposes of Section 23. It is completely different from the question, what is the reason for the treatment they receive? And so the comparison is between a woman who has chosen to make her home in London, or whose family live in London, and a man who has chosen to make his home in London and who has family in London. And the question there is the woman less favourably treated than the man in relation to access to an AP? And if so, is it because of her sex? And the answer to both of those questions is yes. To say it's not because of her sex, it's because she's chosen to make her home in London, is a completely circular answer, which doesn't assist in addressing the statutory question.
Yes, I think that was your answer when you were looking at 48C. In the respondent's case, you made that point.
Yes.
In 48C, where they said there was two factors,
yes.
Location of home and the location of the APs.
That's right, my Lord. And the point is pointed up very starkly by the proposition that my Lord Toulson put that was accepted by Mr. Yes. Chamberlain. Yeah. He also sought to develop a submission, which I have to confess I didn't entirely follow, that the detriment or the less favourable treatment was not the lack of an AP in London, but losing contact with the family. And he said, oh, well, the causes for that could be all sorts of things and not sex. He is there, with respect, confusing the less favourable treatment, which is the lack of any opportunity to be placed in an AP in London, which is caused by sex, and the disadvantages that flow from that, the detriment that flows from that to the individual, which may include simply a lack of contact with children, mental health difficulties, inability to get accommodation, and so forth. Those are the consequences that flow from the less favourable treatment. Now then, he said the consequences, if we were right, is that there could be discrimination claims by men who lived in Bedford and had to go to a facility down the road from Bedford. Now, your lordships and your ladyship already have the answer that I gave in my opening, but there's a further point. And the point is that what must be justified here under Schedule 3, paragraph 26(2), is the more limited provision. It's not the placing of one facility in Bedford or another facility in Reading, or the lack of a facility in London. You have to start by asking, what is the public function in this case? The public function in this case is the Secretary of State's statutory function under Section 2 of the Offender Management Act 2007, which is the function of ensuring the provision of sufficient approved premises throughout England and Wales for the purposes of supervision and rehabilitation. So what has to be justified is not the placement of each individual facility, but the overall configuration of the network and the systemic disadvantage to women that arises from that configuration. So if the Secretary of State was able to justify the particular provision overall for men and for women, she would be safe from claims from men who live in Bedford. We then come to the question of indirect discrimination. And what my learned friend says is, oh, well, the only PCP you identify is the requirement that you must reside in approved premises. That's obviously justified because the Secretary of State needs to keep you under close supervision. With respect, that is, of course, missing the point, which is that the PCP must be justified having regard to and notwithstanding its discriminatory effect on women. So if this is in truth a case of indirect discrimination, you cannot justify the application of that PCP to a woman without asking whether it's, the requirement for it to be imposed is outweighed by the detriment to her of its imposition. And that requires the inquiry that has never been made. How great is the detriment? What measures can be taken to mitigate it? Because if it could be concluded that the purposes could be met equally well with a differently configured network, then they cannot justify that PCP. And whichever way you look at it, you always end up in Schedule 3, paragraph 26.2. You always have to justify the more limited provision.
Follow all of that, and as you've said, in this case, it doesn't matter whether a discrimination, if there was such, was direct or indirect because of Section 29 and Schedule 3. You know, I've been troubled about the implications in relation to the prison regime. Now, if a court sentences somebody to imprisonment, then the duty of the Home Secretary to hold that person in prison. At the moment, it seems to me very difficult, very artificial, to say that the Secretary of State is providing a service to the person who the court has ordered to be detained. Therefore, if it's direct discrimination in Section 13, follow, I think, that any prisoner who could say, look, here, I am in fact in a worse position because I'm a long way away from home, would have an answerable claim under Section 13 with no ability to justify proportionality because we wouldn't be in Section 29 territory. If, however, the correct analysis were that the treatment is the requirement of somebody to live in an AP which is nearest to their home, then there wouldn't be direct discrimination. There would, on your argument, be indirect discrimination because of the way in which it's configured. And if you then take that to the prison estate, it would be open to the Secretary of State to be able to say, but I can actually justify why the women's prisons are in this way. It's rather long-winded, but it doesn't arise in this case. But the principle could be very important.
Well, my Lord, of course, if there's no provision of a service and you're not within Section 29, then you may not be within the scope of the Equality Act at all.
Why not?
Because under the Equality Act...
Section 13.
Well, Section 13 simply defines discrimination. It doesn't tell you that discrimination is unlawful. In order for discrimination to be unlawful, it must fall within one of the circumstances in the Act in which discrimination is unlawful. Classically, employment, the provision of goods and services, the provision of housing are good examples of circumstances. Discrimination is not unlawful in all circumstances. And there are specific exceptions, for example, for acts done under statutory authority. Now, for those reasons, I would submit that it would be most unwise for us now at 5 to 4 to start opening what is a completely different can of legal worms. Because the question whether it's within the scope of the Act, if so, what exceptions would apply? Because this is a very detailed statutory code. What exceptions would apply and what tests would apply is completely context specific. You cannot simply say, if this applies to APs, it also applies to prisons. And my Lord, I don't have at my fingertips the ability to give your Lordship a comprehensive answer about a completely different statutory context.
But it is definitely the case that all Section 13 is doing is defining direct discrimination. Then other sections in the Act make direct discrimination unlawful in certain circumstances in relation to certain activities.
That's right. Yeah. That's right.
That's the situation.
That is the position, my lady, yes. Now, so far as the test for justification is concerned, there's no deliberate policy decision here. And when my Lord Wilson asked that question, it was very elegantly sidestepped by Mr. Chamberlain, who didn't, in fact, answer it. The evidence, and indeed the findings of Mr. Justice Cranston, is that there was no policy decision at any stage in this case. And therefore, the territory we're in is the territory described in Brewster, paragraphs 64 to 65. I don't propose to go to them now, but simply to alert the court to them, where there is a discussion of the fact that it's inappropriate to apply that sort of broad margin of appreciation where there has been no conscious decision about the deployment of scarce resources in a socio-economic context. Seymour Smith is a case of macroeconomic policy. This could not be more further removed. The point about the failure to do the things that Mr. Justice Cranston proposed in the paragraph we've looked at is not that, as a matter of law, a failure to comply with the public sector equality duty means they can't justify discrimination. I've never suggested that. The point is that what he was proposing to them were the minimum factual inquiries that the Secretary of State needed to make in order for the Secretary of State to be in a position to answer the basic questions that the justification test required. What is the extent of the disadvantage? What is the extent of the detriment? What measures would be available to mitigate the detriment? My learned friend keeps talking about how, however you configure it, there won't be equality. That's not the point. The point is that there may be alternatives which are less disadvantageous. We don't know because the Secretary of State's never done the work. What would be the costs and the countervailing benefits of the alternatives? And it's no answer to that to say, oh, well, you need at least 2 members of staff and it costs $750,000 a year to run an AP. That's simply one small part of the cost equation on one side without any consideration of what countervailing savings or benefits there could be. And the point is simply that on the facts of this case, having at no stage ever done the investigation that Mr. Justice Cranston required them to do, they simply cannot produce the evidence that would be necessary in order to justify the discrimination in this case. Let me just give the court one example. They say, oh, well, if you had twice the number of APs, you'd have half the number of women in them and you'd have a higher staff-to-woman ratio. If the court goes back to the 2013 report of the Parliamentary Committee, which is in Appendix Part 3, pages 574 to 6, you will see that what that committee was saying was if you configure your women's APs better, if you have a wider geographical spread, you will find that more women are able to use them. Because the disadvantages of women being separated from their children will be less, and you will be able to make better use of your system. So the number of women who can use APs is not a static figure. It is artificially reduced because of the limited network that's available.
Could you give me those page numbers again?
Yes, my Lord. It's Appendix Part 3, pages 574 to 576. It's the parliamentary report we looked at earlier.
Yes,
finally, it said that there was no evidence of the knock-on consequences. That is, with respect, untrue. There was such evidence in the 2008 Joint Inspection Report. If we just briefly turn it up, it's the Appendix Part 2, page 394, Section 8. And, for example, if you look at paragraph 8.1.3, on page 393, the number and location of hostels for women perpetuated the discrimination experienced by women in prison, and that a higher proportion of their men were forced to stay a long way from home. For women in particular, enforced separation from their families and support networks compounded the problems associated with their offending, e.g. relationships and mental health. So there's a finding about impairment of mental health. And over the page at 8.1.7, given the location of the 7 hostels, it followed that many potential residents would face several hours of travel to visit their children. Travel was expensive, unlikely to be direct given the geography, and slow. In addition, as most hostel residents had lost their own accommodation, regaining suitable accommodation for themselves and their children in a different part of the country could seem or actually be insurmountable. So there is the finding of the ongoing knock-on consequences in relation to accommodation, which have in fact, of course, materialised in the case of Ms. Coll.
Can I just ask you one question that's probably irrelevant to the issues which we're actually considering, which is, what do we have an account of where Ms. Coll is now?
Yes.
And where is that in the documents?
It's not in the documents, my lord, but I can tell you on instructions that she spent almost a year in the Bedford AP. She suffered the difficulty that she was asked to look at accommodation in London, close to her children and grandchildren, but was unable to get travel warrants to visit it. As a result, she has been allocated accommodation in Milton Keynes, and she is now living in Milton Keynes. And she is very unhappy about that situation. But
What, in an AP?
No, she's got a flat.
She's now living in social housing.
Social
So
housing.
she's in the community now.
She's in the community now, but she was required to take that because if she hadn't, she would have been regarded as intentionally homeless. So she has suffered precisely the knock-on consequence that we refer to. Now, the final point is the wording of the declaration. You should all have on your desks our proposed wording, and if there are any questions that you wanted to ask about that, I'd be very happy to deal with them. We've simply tried to make it as general as possible.
Have you got it?
Got it somewhere.
Yes.
I read it, I know about it.
Yes.
Yes, I've got it.
Well, it may be, of course, that we don't get there, as Mr. Chamberlain says, but if we get there, it may also be that we would welcome further submissions on the precise form of relief, which is not uncommon. So,
Unless I can be of further assistance, those are our submissions in reply.
it looks as if you can't. Thank you very much indeed. Thank you to everybody for dealing with this tricky case in such an efficient manner. Some of us have now got rather painful hands writing notes. We will consider what our answer will be and let you know in the usual way. Thank you very much indeed. Court is now adjourned.